Go.
Hello, my name is Attorney Dan Hilbert. I'm a lawyer here in the state of Florida. I've been asked by Ms. Jonna Furman to make a statement on my perception of Florida Statute 39.806. I previously had the privilege of representing Ms. Furman in some causes of action up in Duval County Circuit Court, and I've agreed to make this statement purely upon the law, as I don't believe that I have any ability to make any comments upon any facts of any cases that may have been in Duval. Suffice it to say, I've agreed to make this video because I do believe that a review of the recent amendment of 39.806 and some debate and discussion of what its intent was and how it's being applied, I think needs to be had. It's my understanding that prior to 2014, 39.806, specifically the subject or the subsection that deals with egregious abuse, previously required that in a subsequent proceeding to terminate parental rights of a parent's rights over a new child required some nexus pursuant to Florida Supreme Court case law. That statute and that sentence that required the nexus requirement was recently removed by the legislature. And it is now my understanding of that law that even if something happened in the past can be proven wrong, no matter what, it can still be used against a parent without any recourse whatsoever in its application of a new case. I think that that law and the way that it potentially can be applied now causes me grave concerns about the due process rights of all individuals. Everybody has the right to be heard and the right to present their evidence. And as a litigator of 9 years, I can honestly say that sometimes you don't have the evidence available for you for your first day in court. It doesn't come till later. I think the Supreme Court had it right in their case law when they interpreted 39.806 to require some form of a nexus between prior conduct and a future act. I think the application of the law, as it may be, that it's done and over and you can't defend yourself, is a potential issue that can cause a person who has corrected their life to be defenseless in a scenario where there's no new evidence and potentially they're being prosecuted once again for old evidence that they can no longer refute. So to that extent, as I said, I really hope that there's some discussion that's opened up on 39.806 as to whether or not a nexus requirement should still be required in termination of parental rights hearings. As a father myself, I know what it's like to have children, and I think that we all need to take a deep look at something when we're seeking to separate a parent for their child. Thank you.